Today we're going to have a bonus free mini webinar, not the regular complexity and length of our regular ones, but a lot of people get into trouble not understanding term of the tenancy, what term means and what it means when a tenant gives notice or fails to give notice. So I'm throwing in a free webinar today to help landlords out, to help them stay out of trouble. The topics today will be the notice to terminate a tenancy by a tenant, the agreement to terminate a tenancy by landlord and tenant, the application for rent arrears without eviction, and the application to terminate the tenancy based on a tenant having given a notice to terminate or signed with the landlord an agreement to terminate. A couple of definitions. The LTB, if you see it in the PowerPoint, means the Landlord-Tenant Board. The RTA or the Act means the Residential Tenancies Act. That's the law that governs all residential landlord and tenant interactions in Ontario. So before you can understand tenants giving notice, you have to understand when they can give notice, what is term versus what is tenancy. And a lot of people confuse the two. A tenant has a tenancy under the RTA, which means it's the entire time they're there and their rights and obligations continue for the entire time until they move out. It could be 1 year, could be 5 years, could be 20 years. The fixed term is different. Most leases, although not mandatory, have an optional period at the start of the tenancy we call the fixed term, usually 1 year. Landlords and tenants agree to that. The landlords try to ensure that the tenant's responsible to pay at least 1 year's rent if they're going to move in. They don't want to go through all that work and then have the tenant move after 3 months. If there is no lease term, then the tenancy is simply month to month. And I'm going to explain what that means and how that changes people's rights and obligations. Some people confuse the word lease with the word term. They say my tenant's lease expires in 4 months. Well, your lease doesn't expire. Only the term may expire, but the tenancy continues and the lease continues to be in force because the lease is just a written agreement. So don't confuse term, which is the initial period, with lease, that is simply the written document. And again, you don't have to have term in the lease. It can be month to month if everybody agrees. Lease term is optional. So lease is the tenancy agreement, but this term, which is the optional period, is problematic because it doesn't mean what you think it means. Under the RTA, term might as well be called keyboard or scissors because it doesn't mean what term traditionally means in a commercial lease or what it usually means in its regular legal sense. So let's look at how the RTA deals with lease term, what it is, and how that affects the notice that a tenant has to give a landlord. You know, or you should know by now, that there is a new government standard mandatory lease that you have to use. And when you use the mandatory standard government lease, there's a section 4, that talks about term. Well, the term, in this case, you would say the tenancy starts on 2018-07-01, July the 1st, and it ends on 2019-06-30, June the 30th, 2019. But it doesn't have to be. You could tick off the box monthly tenancy, and if you did, that's what it would be. It's very clear as you read this below, when term ends, the tenant does not have to move out. And a lot of landlords get confused because they think they do, and that starts a lot of problems. So the tenant doesn't have to move out. What happens? It just becomes month to month. There's no renewal. There's no requirement to renew. There's no requirement for anybody to advise the other party. If a tenancy agreement has a fixed term, which is optional, and the parties haven't decided to renew it for an additional year term, or if the tenancy hasn't been terminated, then it's deemed to have been renewed. And everything in the tenancy agreement, that is the lease, is in force. The only thing that may change is that there may be rent increases if done properly in accordance with the RTA. So why do landlords like term? Because they think the tenant has to pay the rent for the entire time they're there, even if they move out early. Why do tenants like term? Because during fixed term, the landlord can't evict for their own use, for their family's use, for the use of a purchaser or their family, for demolition, extensive renovation, conversion to non-residential, or for persistent late payment of rent. Why can't you evict for landlord's own use, purchaser's own use, even persistent late payment of rent during term? Well, during term, the government decided when they drafted the law to give them a break. And they did that because the tenant is guaranteed a year's term unless they do something bad, if there's lease term. And the N12 and the N13 for eviction for landlord's use, purchaser's use, demolition, change of use, we call those no-fault notices. The tenant's done nothing really wrong. The landlord wants to move in. And the landlord has no right to serve them with a termination notice if they're in a fixed-term tenancy. They can only do it if they're month to month. That means that eviction applications for landlord's own use, purchaser's use, etc., can't be used during lease term. So who wins? Well, I think tenants win. I think term for landlord is meaningless and sometimes harmful. The tenant can't be evicted for certain of the no-fault reasons or for persistent late payment of rent. Landlords get something. They have some certainty, that the tenant will stay for the entire period of time before they move out. So what happens if a tenant wants to give notice? A tenant wants to leave, they want to move out. Well, one of the problems with tenants giving notice is often they don't give proper notice. They give an email, they give a text, they talk to the landlord, they phone the landlord, but that's not valid notice to move out. So one of the things landlords have to get better at is insisting that when a tenant says, I'm moving out, that you insist on the tenant giving you an N9 notice to terminate the tenancy. The law says that just as landlords have to give proper notice to terminate the tenancy for other things, a tenant has to give proper notice to terminate the tenancy if they want to move out because they want to move, they want to go somewhere else. So the tenant's obligation to give notice works like this. Tenants have the right to leave, but there's rules. They have to give proper notice with a proper period, and they have to use the proper form, and they have to respect the rules about fixed terms if they've agreed to a fixed term and are in a fixed term. And if they don't respect those rules about termination date, the period of the notice, the fixed term rules, then you may, and I emphasize may, be able to sue them for any losses in rent, any gaps in rent before you can re-rent. So here's the rules. Where the Act allows either a landlord or a tenant to give a termination notice, but we're talking about tenant notices, it has to be on an LTB form. It has to have the address of the rental unit, have the specific date on which the tenant sees to terminate, and has to be signed by the person giving the notice. A tenant can terminate a tenancy by serving the landlord with an N9 notice, but it has to be effective for the last day of a rental period, or if there's lease term, no earlier than the last day of the lease term. An N9 notice has to be given at least 60 days before the date of termination in the notice, and again, last day of a rental period and no earlier than the last day of a lease term. If it's a fixed term lease and the tenant's still in term, in other words, they moved in May of 2018 and now it's October of 2018, legally, they may have an obligation to continue to pay rent until April 30th, 2019, because they're not supposed to give notice before the end of the lease term. And if they do, if you give notice prior to the last day of the lease term, the landlord may be able to sue for the rent up until the time the tenancy should have ended. But here's the catch: only if the landlord tried to re-rent but was unable to re-rent. You can sue for this unsatisfied lease term or short notice, either at the LTB if you file while they're still in possession of the unit, but once they've moved out, if you haven't filed, you have to bring the claim to small claims court. But again, it's not easy because you have to prove that you've tried to mitigate, that you tried to re-rent, you were unsuccessful in re-renting without a gap, and you've suffered some monetary damage. There's another notice that tenants can serve and sign along with the landlord signing. So either the landlord or the tenant can talk to the other and ask them to sign the notice. And it's called an N11 notice to terminate the tenancy. The N11 notice is different from the N9 because it's not actually a notice, it's an agreement. An N11 is an agreement between the landlord and tenant saying that the tenant will move out on a certain day. They need to both sign it in order for it to be valid. But with an N11 notice, there are no timing rules. In other words, with an N11, you can agree to end the tenancy on any day with any numbers of days, even if you're still in lease term. So the N11 really is about the two parties agreeing that the tenancy will end, notwithstanding any rules. Now, what if the tenant signs the N11 and the landlord signs it and the tenant doesn't move? It's easy. There's an application to the LTB called an L3. L applications are applications by the landlord. The L3 is an application to evict based on an N9 or an N11 notice being signed and the tenant didn't move out. The N11 agreement often comes about as a result of disputes, and the landlord and tenant talk it out. Maybe the landlord gives the tenant some money or some time, and the tenant agrees to sign the N11. Often there's a side agreement, and I do a lot of those, that are a companion to the N11, that the parties sign to deal with the other things, such as damage or forgiveness of rent or acknowledgements, things like that. And when the side agreement and the N11 are signed and compensation is paid, you're really pretty much guaranteed your eviction. Some landlords say to me, isn't it illegal if I bribe my tenant to leave? Well, it's not a bribe, it's an offer. And there's nothing illegal about making an agreement to move out, as long as it's done in good faith, as long as you don't misrepresent things, coerce the tenant, etc. So an N11 agreement is very simple. Landlord name, tenant name, rental unit address, the date where the tenant is going to leave, which can be any day, not just the last day of a rental period, and it's signed by both the parties, all the tenants and the landlord. And once that's signed, the landlord is free of the tenant after the termination date. There were some new rules in 2017 as a result of the former Liberal government's Rental Fairness Act. They made some changes about suing tenants for rent arrears if the tenants have moved out and the tenancy ended. And basically what this says, and it's crazy and it's so unfair, is that if the tenant gives you notice they're leaving and the tenant says, apply my last month's rent to June, I'm leaving at the end of this month, and you say, no, notice is 60 days. Today is June the 14th. The earliest the termination should be is August 31st. So they say, the heck with that. I'm not paying you June. I'm not paying July. I'm not paying August. Use my last month's rent for today, June, for this month. And you serve them an N4 for unpaid rent, and then they move out. That ends the tenant's obligation to pay for any damages, for any gap, for any future rental loss. This change to the law encouraged lease-breaking behavior. So for instance, if a tenant wanted to get out of lease term, all they have to do is have a wild party, force you to give an N5 notice to terminate based on their conduct, move out, and then the tenant has no obligation to worry about whether you can re-rent or not. The tenant can move out without being sued. Completely unfair. Here's what the section says. No landlord shall require or attempt to require a former tenant to pay rent money if the tenancy is terminated and the tenant vacated the unit. Section 37 says a tenancy is terminated, 37 sub 2, if a notice of termination is served on the termination date in the notice. So that's a problem. Section 37 says if you serve an N4 or N5 or N anything, the tenancy ends on the termination date in the notice. And that's a big problem, because what do you do if the tenant owes rent and says, use my last month's rent deposit for June, I'm leaving the end of June? If you serve a notice to terminate, you're in trouble. So what do? Well, don't give them a notice. But how do you do that? How do you get your money? I want June's rent and July's rent, and I want the last month's rent applied to August. Of course, it could be earlier. If I managed to re-rent for August 1st, I would want June's rent, and I would want the last month's rent applied to July. But in any event, I can't rent the place in 2 weeks, and I want my rent money for this month. Well, what I do is I file an L9 application at the Landlord-Tenant Board instead of an L1 application, which involves serving a termination notice called an N4. Since you didn't serve the N4, the tenancy doesn't end. L9 only asks for an order for money for the rent arrears. If you didn't file while the tenant wasn't living there, of course, you could make the claim at small claims court for the rental loss, but that's crazy. If the tenant still is living at the unit and says, I'm not paying June, and it's June 14th, you should file the L9 application to the LTB right away and get a judgment for the rent. These are LTB applications. These are all the different applications for all the different things. The most common, of course, the L1 for arrears of rent. But right now we're talking about the L9, which is an application just for money without an N4 notice of termination being served. And this is what it looks like. You put in the landlord name and the tenant name and the amount of money they owe, and you describe what months are owing, etc. And you go to a hearing. And at the hearing, assuming you haven't managed to re-rent and you've tried to re-rent, the board will give you a judgment for that money that was unpaid. You fill in the amounts here, any NSFs as well. As long as the tenant's still in possession, when you file, you can go to the landlord-tenant board for this judgment. So here's what an N9 notice of termination by a tenant looks like, properly done. This is a good notice, 60 days minimum for the end of a rental period. So here the tenant said, I'm moving out July 31st. When did they sign this? May 24th. So May 24th, June 24th, July 24th, got to be the last day of a rental period, July 31st. So it follows the rules. In this case, we're assuming no lease term. He's given 60 days minimum, effective the last day of a rental period. So this is a good notice. He would pay for his rent in May. He would pay for his rent in June. And the tenancy ends July 31st. You would apply his last month's rent deposit. If he didn't pay for May or June, of course, you would file the L9 application because you've got this N9 in your hand if you need termination. You don't need termination with rent. You've already got the N9 termination notice because once he signed the N9, you can easily evict by filing an L3. If the tenant doesn't move out after signing an N9 or N11, you just file this L3 application to the board without even going to a hearing. The L3 is used if a tenant gives notice to leave or the landlord and tenant sign an agreement to leave and the tenant doesn't move out. In fact, you can even file it before the termination date in the notice, but of course, the board will not issue the eviction order for a day earlier than the termination date in the notice. So if you agree to part company, either with an N9 or N11, you can file the L3 application. The L3 is very simple. Landlord name, tenant name, rental unit address, and you fill out the part that says the tenant agreed to move out, which is the N9, or the tenant agreed to move out, which is the N11, or the tenant gave me notice to move out, that's the N9. You put the date, you sign it. You have to include a copy of the N9 or N11 when you file it with the board, and there is no hearing. They issue an order just based on the N9 or N11 and your affidavit. You have to swear an affidavit saying, I'm the landlord, the tenant asked to leave, we agreed to fill out an N11, or whatever the circumstances are. I'm applying to the board for an eviction order on a without a hearing basis, ending the tenancy and evicting the tenant. It's as simple as that. Once the board gets a copy of the L3, they issue the eviction order without a hearing, and the order is effective on the date of termination in the notice. From time to time, there is a hearing because the information in the L3 is not complete. The board member has questions. The affidavit is confusing. The member is suspicious or doesn't understand it. So from time to time, it may be sent to a hearing, but usually these L3 applications are ex parte. In other words, one-sided only based on your written application with the affidavit and a copy of the N9 or N11. Because it's ex parte, in other words, the tenant didn't know you were filing it, the tenant didn't participate, there is a process where the tenant can set aside the order if they disagree with it. For instance, if they think you forged it or they signed it without having mental capacity. But unless there were strange circumstances such as a forged signature or coercion, the board will almost always uphold the eviction order. So here's another N9 notice, but this one's bad. It was, let's go to the second page, signed on May 24th, but for June 30th. So that's only 36 days. So what to do? If the tenant gives you a bad N9 because it's not 60 days or not the last day of a rental period, then it's not valid and you could sue them for the gap up to the day you managed to re-rent or up to whenever the proper day that should have been the termination date. So in this case, for instance, May 24th, the landlord could sue to July 31st because that would be the day that the tenancy should have been terminated. But sometimes it's better to just let it go. If the tenant gives you a bad N9 notice, is it worth it to sue them for a month, go to court, have to enforce the judgment? Sometimes you just say, look, you've made a mistake. You've only given me 36 days, but sign this N11 agreement and I'm okay with it. Because if the tenant and you sign the N11 agreement, the tenant doesn't have to follow those 60-day last day of a period rules. But even if it's 60 days and last day of a rental period, it still may not be good. What if there's lease term? Well, if there's lease term, again, the Act says the N9 can't be effective earlier than the end of the lease term. If they give you a bad N9 because of lease term, and you're happy enough to have them leave, again, the same thing applies. Rather than sue them, you can say, here's an N11, good luck, I want you to sign this so that I can start the process of re-renting the unit. Because remember, the N11 doesn't have any rules about timing or rental period or tenancy term, etc. It's an agreement. It can be for the next day if you wish. And this is an N11, and again, it can be for any day, July 20th. It doesn't matter. This is May 24th, effective July the 20th. So if an N9 notice is bad and you don't want to lose money, you don't want to just sign the N11, what do? Well, if they give you short notice, less than 60 days, not the last day of a rental period, before the period ends, for instance, December 13th, well, the law says the tenant has an obligation to pay rent until the date the proper termination should have been. And if they don't pay you, you can sue them for that gap. But, as I said earlier, you have an obligation to try and re-rent, that's mitigate your loss. And if you're successful in re-renting without a gap, the tenant doesn't owe you any money. If you don't try to re-rent, the tenant doesn't owe you any money. You're not allowed to double collect rent. You're not allowed to take the money from the tenant even though you've managed to re-rent without a gap. The law says that in Section 88. So that's the way lease term works in respect of notices to terminate by a tenant and agreements to terminate. I hope you learned a lot from this today. You can get into a lot of trouble not understanding notices of termination. One of the biggest mistakes landlords make is that they start to re-rent based on a verbal notice or an emailed notice, and then the tenant who's living there changes their mind. You must insist on a notice of termination, an N9 or an N11 if the tenant says they're leaving. Otherwise, you re-renting is awfully risky. I've also got some good documents that are part of my webinar package. So for instance, if a tenant gave notice to terminate and that notice was short or that notice was verbal, you could give them with this document a letter explaining that the law says this and you haven't done this, therefore no proper notice has been given and rent continues to be due. So there's a webinar series that we have. I may have mentioned it earlier. The webinar series covers everything to do with residential tenancy law in Ontario, from starting a tenancy to rent control, rights and obligations, evictions for conduct, evictions for rent, evictions for landlord's own use, tending the landlord-tenant board. There's so much information in the webinars, you can become a real expert. We've just started a new product called a new Landlord 3-pack. If you really don't know the rules, the 3-pack is a bargain at $245 plus HST. You get starting a tenancy, rent control, rights and obligations. So not the eviction stuff. Hopefully you haven't needed that yet, but it tells you how to get started on the right foot so you have a trouble-free tenancy. I hope you've enjoyed this webinar, and happy landlording.